A very big welcome and thank you to everyone for joining us today. I was tempted to say, welcome to Cilla's HR House of Horrors, but that just sounds like a really cool Halloween party, more than an employment law update, but I would happily attend both, Cilla.
Excellent.
I'll kick things off with a short intro and a summary of the session today. So I'm Angela Franks and run Fraser Jones in Australia. For those who don't know us, Fraser Jones is a dedicated and specialised recruitment agency. We focus on HR, people and safety. We're a global business, but we have local teams mainly in Sydney and Melbourne, but we now have Kate Benson in our Brisbane office, which we're very excited about. And we service clients all over Australia and New Zealand. The session's going to be broken into two key sections where Cilla's going to update us on sort of recent and topical employment law updates, and then run us through, I think you've got about 5 of the common pitfall areas for HR. And this is what we've kind of coined as the HR horrors. It's going to be sort of slightly interactive where we've got a few polls, you can vote, it's a scenario-based questions. But to that end, Cilla, absolutely delighted to have you on as always. Cilla's a partner at Clayton, specialising in workplace relations, employment and safety. Cilla will be, as Cilla's presenting, I'll be keeping an eye on the Q&A buttons. So I'll monitor the chat and the Q&A as we go. And then maybe at the end, once we've finished, we'll go to some of those questions. And I will be sending, we're recording the sessions, which we'll send out in a few weeks, but we'll also send the slides out probably like later this afternoon or tomorrow. So everyone who's joining the session is on mute so that we can record. And I think that's it. Over to you, Cilla.
Awesome. Well, thanks very much, Angela, for having me again. It's nice to feel connected, and it sounds like we've got a pretty decent group of people. Maybe we got in just before everybody was back at work and people start getting busy with the Christmas fun. But look, as Ange mentioned, we're going to be talking about HR horrors today, and we thought it was a fun name given Halloween is just around the corner. But legitimately, as an employment lawyer, we see a lot of repeat HR horrors, and some of them are really problematic for us. So when Angela mentioned the topic, I was keen to impart whatever knowledge I can to all of you. So in terms of the session, there we go. The overview, as Ange mentioned, will be a quick overview from an employment law perspective. There's been a lot happening this year with the pandemic. So we thought it'd be remiss of us to get together and not talk about some of those things, but it really just will be a very quick highlight. Then I'm going to talk about some of the common pitfalls or horrors that we see. I could talk about these things all day long. So they are just a selection that I've picked to highlight today. And then to take it out of the abstract, I'll be talking through a case study, which will hopefully bring some of those horrors and concepts to life for all of you. Hopefully it won't put any of you into your own state of PTSD as a result of remembering things that you've encountered yourself. And then we will have some question time at the end. And look, that can cover both the employment law update as well as the HR horrors part of the session. So in terms of the employment law update, of course, the big issue on everybody's agenda is returning to work post-pandemic. What is that going to look like in Australia? Fortunately, in New South Wales, we have our freedom already. Our Victorian brethren are getting a taste of the freedom post worldwide record-breaking lockdown, I think, on Friday night. So returning to work is front of mind for all Aussie employers. And I think the thing to remember in what is a genuinely navigating area of the law to navigate at this point in time is that as employers, as HR professionals, you need to keep in mind that as the employer, you have the paramount role of keeping a safe working place, keeping your workers safe at all times. So in that context, many employers are considering, do we need to mandate vaccinations? And of course, as you'd all be aware, there's different approaches that are being taken in states and territories. So it's a bit challenging to navigate if you are an Australian employer or an international employer because there's different laws and different public health orders in each state and territory. But we're getting now to a point where we're starting to open up and where there is an expectation that with freedom will come a little bit of a spike. So essentially that duty of care that we have under work health and safety laws does give us an ability to say, in order to keep our workforce safe, we need to take certain measures, and companies are then navigating what that might look like for them. So things like ensuring compliance with public health orders, critically important. Most of you will be across that already. As we're returning to the office, things like having COVID-19 safety plans, having real rigor around management protocols that you can deploy in terms of social distancing, air ventilation, good sanitation. But then more importantly, as we are returning to the office, having procedures in place so that you can easily notify staff and health authorities when you have COVID positive cases. And look, there will be an inevitable spike. Hopefully with everybody being vaccinated, we won't be seeing the deaths, but it is expected that notwithstanding the vaccination, people will be catching COVID. So unfortunately, it's not a set and forget scenario for the HR and safety personnel within your organisation. So that's the work health and safety side of returning to work post-pandemic. Of course, the big part of that is vaccinations. Mandatory vaccinations are receiving a lot of press. There's certain industries and jurisdictions that have essentially mandated vaccinations, and you will have seen in Victoria and just today, Western Australia is imposing mandatory vaccinations for very broad categories of authorised workers. So unfortunately, we haven't had a government mandate either from Commonwealth or state governments just across the board in terms of just giving employers the tick to say you can require that all staff are vaccinated. So what we're seeing because of that absence of clarity from the government, we're seeing corporates having to really lead the charge and set those processes for other organisations to look to. So when you're thinking, if you're in the tent on mandatory vax discussions within your organisation, some of the considerations are, do we mandate or do we strongly encourage? Now, most organisations have been strongly encouraging, but now we are starting to see more mandatory vax positions being adopted by companies, which is a welcome change from a work health and safety perspective. It's obviously the easiest thing to do to keep both your workers safe as well as anyone else who might be visiting your premises. So in that context, things to think about in terms of whether you're going to make vaccinations mandatory are, of course, the public health orders. They're being released regularly. You know, we were seeing changes on a monthly and weekly basis. So keeping abreast of those changes is critically important to make sure they don't impact on your position. And then essentially ensuring that where you have mandated a vaccination, that you have the support that sits with that. So it's not just saying you have to get a vax and that's it. Ensuring that you've got a COVID-19 policy, ensuring that you've got a risk assessment and a COVID-19 safety plan will all help you position the need to have a mandatory vaccination stance. And of course, in circumstances where people refuse to get vaccinated, where people are reluctant or might have a health condition that means they can't get vaccinated, the position is that if somebody is not vaccinated, then you should continue to let them work from home until such time that we get to a position where we've got real clarity from the governments that will allow you to take a bit more of a bolshy stance on that. Now, I say continue to let them work from home. Of course, there's many people who can't do their work from home. So in that scenario, we are starting to see a response, and we're starting to see cases where organisations have adopted a mandatory vax position and are starting to get staff who are refusing to comply with that. So we're seeing unfair dismissal cases, we're seeing discrimination cases and adverse action cases where people are saying that it's unfair that they might be performance managed or they might have their employment terminated because of their refusal to be vaccinated. So we've seen some strong positions supporting mandatory vax in both the Fair Work Commission and recently in the Supreme Court, but we've also had some pretty strong dissenting views which have really enlivened the anti-vax debate. So we expect that that will continue for some time, and all manner of interesting reasons are coming up in that context. We're seeing religious grounds, we're seeing people saying I'm vegan, so I can't have the vaccination because it has egg in it. And so people are coming up with all manner of different reasons why they are resisting it. So it is important to note that it could be discrimination to require someone to have the vaccination. So the normal things that you navigate in terms of discrimination laws, unfair dismissal, adverse action, continue to be something that you need to be mindful of. And of course, people just saying, that they have a right to choose what they put in their body. So it's a bit of a watch this space at the moment, but you will have seen that there are cases coming through that are generally supporting employers' position to take quite a firm stance, whether they're in a customer-facing or a public-facing role or not. So that's a very brief cover off of return to work and vaccination. The other thing that I wanted to mention at the outset is the change to casual worker status. So this has been something that is a really big change from an employment law and HR perspective. We've seen substantial law reform after a number of different cases in the federal court and high court that really created quite a lot of uncertainty. The government has now issued legislation to clarify what a casual is. So the law has now clarified that there's a definition of what a casual employee is. It's in the Fair Work Act, and specifically the National Employment Standards in the Fair Work Act have been updated accordingly. There's now protections so that casuals can't double dip by getting a casual loading, as well as leave entitlements if they're found ultimately to not have been classified correctly. And probably most importantly for all of you as HR professionals in the go forward piece is that there's now an express right for casuals to request a conversion to permanent employment. And importantly as well, there's an express obligation on companies to make offers of conversion to casual staff. So it's quite a significant change. Most of you will have had to consider last month pushing out some offers of of conversion to your casual staff. But again, it's something that you need to keep abreast of to ensure that you're complying with those casual law changes. And I guess the only other thing to mention on that front is that it used to be the case that the courts would look at both a contract, but they would also look at the relationship between a company and a casual in determining whether a person was a true casual or not. So they'd look at whether there was a regular systematic work, and they'd look at that history of the employment relationship. Now that has changed, and the new definition means that that determination will take place when the offer of employment is made. So that's quite a significant change. And essentially, if you're offered a job and there's no firm advance commitment that the work will continue indefinitely, then you will be a casual employee for the purposes of the Fair Work Act and legislation. So we no longer are navigating a situation where the relationship is going to drive that determination. Now we're simply looking at the status that was established at the outset. So that's really helpful from an HR perspective, from a company perspective. What I would say to you practically is that if your business is asking you to bring on a casual, then because of those rights to convert from a casual to a permanent employee, I would recommend that you really stress test, should this person be a casual? Why do we need them to be a casual? Because essentially, in circumstances where they're going to be on the books for some time, you'll likely need to pivot them across if they are essentially working and there's a continual business need along the track. So that, casuals again, and I know I'm preaching to the converted, should really be used for those ad hoc pockets of work, genuine casual engagements, rather than just, calling them a casual because it will be easier to terminate their employment, or reasons like that, which all of you no doubt would have seen in your businesses occasionally come up. So with that very quick introduction to the lay of the land and the big ticket items that have occurred this year, I'm now going to move on to some of the HR horrors. So I should say from the outset, I'm going to be talking about pitfalls, HR horrors, but as an employment lawyer, I wanted to say I appreciate how hard human resources business partner land is. We deal with HR staff as much as we do with lawyers in terms of our client base. So we really do understand the challenge of your role. So I'm highlighting some common traps, and these are traps that we see even our most sophisticated clients and experienced HR professionals sometimes falling into. But in highlighting these issues, I wanted to acknowledge that quite often we understand that it may be that the business is hampering your ability to make the right decision or to do your job well. So please don't see today's discussion as the nasty employment lawyer wagging her finger at you. Really, is this just acknowledgement of some of the common challenges that we see? Sometimes it is matters that are actually completely outside of your control. So hopefully after today, you'll be a little bit more cognizant of some of these things so that you can then just be agitating a little bit more, asking questions, perhaps even using this seminar as a basis to push back on the business if it seems to you like something's going down a path that is not going to be helpful in the long term. So look, the first thing I wanted to talk about was restraints of trade. So as you'd be aware, restraints of trade are things like non-competes and non-solicits. These are obligations that are in people's employment law contracts that will limit their post-termination behaviours. So lots of organisations use them. And lots of organisations have post-employment restraints in their contracts without really much question as to whether they should have a restraint or not. So the first thing I wanted to mention is that when you're looking at contracts, when you're populating a template for the business, to query when you see a restraint of trade, does this person need to have it? Because if you've got a restraint of trade for a secretary, for a junior burger employee, for example, that has no real, legitimate business interests that are worthwhile protecting, question whether you need that to be in there at all, because 9 times out of 10, there's no need to have it in there, and it might be the cause for some concern for that employee in taking their role. So query whether you need it. Of course, in circumstances where it's determined that it is a role that ought to have the protections of post-employment restraints, then turn your mind and engage with the business on whether the restraint is sufficient. Is it enough? Is it too much to protect the legitimate business interests of your organisation? Because that ultimately is what restraints are there to do. So some of the common pitfalls we will see is not having effective restraints for senior personnel. So you might have a CEO, some C-suite or senior manager, or for example, someone that's in sales that holds a lot of relationships where they have an ineffective restraint or a restraint which is not enough to protect the business. So is the restraint long enough in terms of the non-competition aspect of it? And the other thing that we quite often see as a corollary to restraints of trade is the notice period long enough for there to be sufficient continuity of business in terms of, for example, a CEO contract that might have a 4-week notice period. So there's a lot of argy-bargy between organisations when people leave in breach of their restraint. So it's just one of those things that we literally are talking to our clients about this almost on a daily basis, where they're either on the receiving end or the issuing end of a nasty letter to another organisation because someone's breached a restraint. So just thinking about it critically. So on the one hand, we see staff that have restraints that aren't sufficient, they're not long enough, they're not broad enough. The flip side of that is that sometimes we see restraints which are just ridiculous, a 5-year restraint covering a whole industry where essentially the effect of the restraint would mean that the person can't get a job at all. So I know that restraints are more of a thing that sits oftentimes with consideration by legal, but I just wanted to put that on your radar, because whilst it might be a matter that's dealt with by legal, invariably HR will be pulled in when someone's been a naughty boy or girl and solicited a bunch of staff or taken confidential information, and 9 times out of 10 you'll be involved in trying to fix that problem up. So again, that's just me imploring you to, if there's a restraint in a contract, to have a think about whether you need it, whether it's going to be effective. So moving now on to ending employment. All of you would be dealing with these matters a lot of the time. And I think probably the biggest issue that we see is procedural fairness. So it's one of the big considerations in terminating employment, and it's not just for staff who have an unfair dismissal right to the Fair Work Commission. Breaches of procedural fairness can be relevant to all staff. It's not just about minimising that unfair dismissal risk. And so really being across all of your policies and procedures, ensuring that you are essentially keeping the business honest and sticking to your own policy requirements as well as the legal requirements is really important, because so often we will see a situation where a company has a valid reason for termination. There's a really obvious reason why this employee has to go, whether it's because of their performance or their conduct, and the company's undone because there's procedural flaws, and that can create really significant exposure. And even if the matter isn't litigated and you don't end up with a horrible judgment that says, yes, this was a naughty employee, they should have been terminated, but company, you stuffed up in these 3 different spots. Even if you don't get to that pointy end of litigation, you will have that person's lawyer, if it gets angsty, pointing out those deficiencies, and you will probably be in a situation where you're then having to pay monies by way of a settlement to this employee to avoid that embarrassing scenario in court. So again, these are things that the business, line managers aren't necessarily thinking about. So it's really important that you get involved in the process and really partner with the business so that you can keep them honest and keep them sticking to the appropriate procedures along the way. So ensuring that you're following your own policies and procedures is really important. Then just also having a think about, is the step that we're taking too harsh? There was a decision a few weeks ago where Amcor dismissed an employee who was absent for an illness, and after their workers' comp payment stopped, they terminated the employee after a month. Now, they then had a general protections claim where the employee was successful because the employer didn't turn their mind to the fact that the employee was on a temporary absence or illness. It was within a 3-month time frame, and there was some really, really adverse publicity for Amcor in that scenario, notwithstanding the fact that it was clear that the employee wasn't going to come back to work, but they essentially jumped the gun in terms of that process. So having a think about those things and just slowing the process down is really important. Another thing that we see quite often is final calculations in termination of employment. It's quite disturbing how often the business will rely on, a deed of release or a payroll statement that isn't actually checked. And so I, again, would implore you as HR professionals to really turn your mind to, are these final calculations correct? Sometimes payroll makes mistakes. Sometimes that function might be outsourced. We recently had what was a legitimate horror where an employee received long service leave with over 100K more than they should have. And we're now in the process of trying to claim those monies back from that employee. And it's incredibly difficult to do that with former employees without essentially having to go and sue them formally in the local or district courts. So again, just a really simple one. Don't rely on the information that you're necessarily given. Just check it. Another thing that we don't see enough is final copies of documents that are provided to employees being kept on file. So all of you would have HR files for the staff. There'd be electronic files. quite often when we have an unfair dismissal or some kind of litigation, we will say, okay, can you give us a copy of the, final warning? Can you give us a copy of the termination letter? And there's no signed copy of the final letter on file. And it from an evidentiary perspective, it's really annoying because essentially the employee has it in their hot little hand. And you see these really embarrassing situations where the company will essentially attach a letter to a response to an unfair dismissal, and it won't actually be the correct final letter that was issued. So it's not just about good admin and document hygiene, it's actually critically important when you get to then litigation that you're keeping those records. So just another thing to be mindful of in an age where, we've got online signatures and things are often emailed, that we actually keep that copy of the final letter. The other thing I wanted to talk about in terms of ending employment is executive terminations and executive employment wrap-ups. They quite often are very tricky to navigate. Usually there'll be quite a lot of stakeholders that are involved, and it might just be, you and the CEO, engaging someone like me to then navigate through, an executive manager termination. One of the things that we do quite often see in these executive termination scenarios is people trying to be nice because essentially senior leadership are having to, get rid of one of their peers. And we quite often see without prejudice conversations not handled well, where in trying to let someone down gently, really inconvenient things are said that can lead the business into much trickier waters. So that's just, again, a reminder that to the extent that you can be in the room for those meetings, try and be there. To the extent that you can give your business leaders a script so that they have less ability to say things that are going to be problematic for the business, the better. Because again, your ability to lead the business and guide what they do is critically important. The other thing that I wanted to talk about was employee wellness. This probably is one where it is quite often HR professionals that are in the hot seat, but sometimes we see in confidence discussions where an employee might raise a concern with an HR professional and says, I want to raise this in confidence, please don't say anything to anybody. And that can create some legitimate HR horrors. And as hopefully most of you are aware, somebody saying, I'm raising this to you in confidence, please don't say anything to anybody else, isn't the end of it. There you have an obligation to your employer. Your employer has an obligation to that employee. So there will be some situations where, notwithstanding the person raises it in confidence, you need to escalate and you need to deal with it. So that's one thing that, again, I'd really implore you to think critically about. Someone said something in confidence, is that the end of it, or do I need to actually have a think and explore whether I need to do something more to potentially escalate a situation? Again, in terms of employee wellness, we see mishandling of investigations quite often turn into employee wellness issues. So situations where, for example, witnesses to an investigation, not necessarily even the complainant or the respondent in an investigation, being impacted quite significantly by a workplace investigation, leading, for example, to extended time off and the like. So again, mishandling investigations, things taking too long, participants in an investigation not being kept abreast of what is happening. These are things where we quite often see significant stress amongst those participants, and it can quite often be completely addressed by HR having a conversation with the staff, keeping them alive to where that process is at, just so that they feel like they're not just sort of suffering in silence. So again, that's just another thing that you can do to try and minimise employee stress in those scenarios. We also see quite often situations where, a performance management process might kick off, and then we'll see it pivot into a person going on stress leave, or the person, taking some extended time off. Now that as most of you would know, is not uncommon, but not handling that process sympathetically and not handling that process well in terms of keeping notes, ensuring that you're still dealing with the person compassionately and not just assuming that there's some untoward reason for that person taking that time off is really important, because what we see very often is these performance management processes pivoting into an unfair dismissal, discrimination or general protections claim, where we find that there's some inconvenient things that have been said along the way that are really not helpful in litigation. And the other thing that I wanted to talk about in terms of, excuse my dog in the background, the doorbell just rang, as you probably heard. The other thing that I wanted to talk about, where I think you guys really can play an important role, is in terms of contracts. So what we quite often see is rolling fixed term contracts, and this really does my head in. As hopefully most of you are aware, if somebody is on a series of fixed term contracts or max term contracts that just are on a rolling basis, they are perceived as an ongoing employee for the purposes of Australian courts and legislation. So if you are encountering practices within your organisation where you have the people on these repeat contracts, then ask the business, why are we doing this? There really isn't much utility in doing it from a legal perspective, because 9 times out of 10 they have the same rights as an ongoing employee, and oftentimes it might be something like headcount, reasons like that, or and that might be a figure that's set by an offshore parent. So again, just asking the question, should this person actually be on an ongoing contract rather than a rolling fixed term contract? Another issue we see is old or dated templates being used. So the law is really changing so often in this space that you almost want to have an annual refresh of your employment templates, just to make sure that you don't have problematic clauses in there. Another thing that I just wanted to focus in on is permitted deductions. So quite often you'll see a contract which says, we can offset any final payment to you by anything that you owe the business. Now, that's fine. You can have it in a contract. The Fair Work Act actually says that unless a deduction is for the employee's benefit and you have their consent, then it will be unlawful. So again, it's very hard to recover payments that you've made to employees and to claw those payments back, but just be alive to the fact that deductions that you make from any final payments do need to be permitted. If you're not sure, get some advice. And on contracts, the last thing I wanted to talk about is sham contracting. So sham contracting is where, somebody is called a contractor, but they are perceived at law to be an employee. And, there's a whole lot of case law that sits behind, is somebody an employee, is somebody a contract? It can be probably reduced to, if it looks like a duck and sounds like a duck, it probably is a duck. But, why do we want to engage someone as a contractor? Quite often the person says, I want to be a contractor. And why wouldn't they? They pay significantly less tax as a contractor than an employee. So again, turn your mind to whether or not somebody should be a contractor or an employee, because if that person looks like an employee, if the business exercises a lot of control over how the work is done, if they're using your equipment and the like, the law will see them as an employee, and there can be significant penalties that arise as a result. And the Fair Work Ombudsman, our regulator, is really focusing in on sham contracting, and it's not just in gig economy Uber type scenarios. They are looking at just normal contractors within big traditional organisations. Now, finally, for this slide, before I move on to the case study, I wanted to talk about workplace behaviour. And over the last few years, since 2017, with the Weinstein scandal, we've seen a real focus on sexual harassment. And so one of the things that organisations are getting criticised for quite a lot in recent times is delaying action when allegations of sexual harassment arise. And in the current landscape, it's just not okay to delay. You need to take action very quickly. The landscape has changed, and it really is the job of HR and in-house lawyers to ensure that organisations are responding swiftly and comprehensively when these allegations come up. Now, it's not just sexual harassment. We see a whole lot of horrors coming up in the context of workplace bullying. As many of you would be aware, bullying is repeated unreasonable action that creates a risk to a worker or group of workers' health and safety. So that's what bullying is, but there is a carve out to what bullying is, which is reasonable management action. Now, reasonable management action is a catch-all that many organisations rely on to excuse bad behaviour. Quite often we see bullying, repeated behaviour, and a company will say, oh, it was just the manager doing their job. So again, it's up to you to really stress test whether reasonable management action is occurring or whether bullying is occurring. Again, just a pandemic related comment. We're seeing quite a lot of examples where social media bullying is occurring. People are online virtually, they're not in the office. And so just a reminder that people's online presence, whether it's Instagram, Facebook, whatever it might be, can be an extension of the workplace. You will get scenarios where people will be bullying and will be found to have breached conduct requirements by misbehaving, for example, on Facebook. So again, ensuring that you've got the ability to use your Workplace Surveillance Act to rely on those kinds of things is really important. So look, I could bang on about these types of examples for the whole day and even more, and I'm sure that many of you will have navigated a lot of these issues, but we thought that we'd use a case study just to draw out some of those common challenges in a context that'll hopefully be a little bit less abstract for you. So moving on to the scenario. So look, should I read it, Angela, or just let people read it? What do you think?
Let me come off mute. If you want to have a glass of water, I'll read it out.
Why don't you read it out? That's good.
I'll read it out, yeah. Shay works for a large technology company, IT Pty Limited. During a one-on-one check-in with her manager, Samir, Shay is told that her performance hasn't been up to scratch. Samir informs Shay that he has spoken to HR, who agrees that a performance improvement plan, or a PIP, is appropriate in the circumstances. Shay is rattled from the conversation with her manager, where he raised his voice, and she doesn't understand why Samir thought a PIP was necessary. Shay contacts her HR business partner, Thomas, to raise these concerns. As it turns out, Thomas is not aware of any PIP in place and arranges a call with Shay to discuss her concerns over the phone while he's out walking his dog. After speaking with both Shay and Samir, Thomas doesn't question the decision or look into any of Shay's performance. Shay is subsequently put on a PIP. Samir can be domineering at times, and after all, it turns out he wanted to avoid the hassle of involving HR, as the team is very busy.
Awesome. So look, what are the issues? Ideally we could be calling it out, but I think it is a common scenario, lots of issues involved. I would say that the main issue is that HR hasn't been involved. You guys really do such an important job. So things that jump out from that slide: HR isn't involved, were company procedures followed, performance management is happening virtually a lot now, but quite often managers are just avoiding those conversations altogether. So remote work isn't an excuse not to have those conversations, and to the extent that HR would normally be involved in those conversations, then encourage your managers to reach out to ensure that HR can still be present in the normal way so that things can occur in an appropriate way. Another inappropriate thing, Samir has misled Shay into thinking that HR was in fact involved. So that probably should have been a little bit of a red flag for Thomas in that scenario. And then Thomas has failed to make any further inquiries about the conversation, with Samir. So the possible bullying complaint in terms of Shay saying that she was rattled seems to have been swept under the carpet or not dealt with properly. And Thomas hasn't really interrogated whether there's any truth to that. He also hasn't interrogated whether the PIP was actually necessary or not. So again, it's just a prelude to our scenario, which shows that getting HR involved early is critically important. And I appreciate that your job is really hard. HR often gets stuck in the middle of office politics, but there's quite hard issues to navigate. So here, Thomas wasn't confident enough to ask Samir whether or not the PIP was necessary, and essentially just dealt with it in a short shrift manner. So look, the first question I have in terms of the poll, and it's just probably a pretty straightforward one, but it is a real horror for us dealing with these issues, is are file notes just for lawyers, or by way of poll, should Thomas take a record of the concerns raised?
Right, so we all vote. Oh, I can't vote, I forgot. Trying to get involved.
Can't vote either.
All right, we'll give it a few. Mel will let us know in the background, I think, once the poll's sort of been final, which we've got enough people who have replied.
And as I said, I'm starting off with an easy one.
We've got a few questions coming through, Cilla, from your first part of the presentation, so we'll definitely get to those questions as well.
Okay, cool.
I think there's about one from each area actually. So
okay, nice. Well, yeah. Mel, we might take the poll results if we can get them. Yay! Look at you, legends. All right.
100%.
Well, of course.
Woohoo.
Excellent. Well, let's
Thanks,
hope
Mel.
we remain. So, of course, prudent approach is to take notes. File notes aren't just for lawyers, especially when employees are raising concerns. And I think the important thing to remember is that HR personnel are really important to us when there is litigation. So a file note is always helpful. If you're giving somebody a verbal warning, take a file note, and it doesn't necessarily need to be a detailed diary note or file note. Even if you're, jumping into a car, a recording on your phone that can be later transcribed is really important. So from our perspective, the important thing is that it's a contemporaneous note, or a note that's taken relatively soon after the event occurred. And this kind of thing is absolute evidentiary gold when we're dealing with these kind of issues. So moving now to the next, there we go, the next part of the scenario. Did you want to read it again, Angela?
Yeah, I can go through it, yeah. Okay. Nina and a couple of people in Shay's team had to take time off work due to stress from Samir's threats about their performance. Nina has seen over 5 of her work colleagues being bullied by Samir, but no one has done anything about it. Nina calls Sally, an executive manager, the chief people officer, and informs Sally about Samir's comments and bullying behaviours. Nina says that she has witnessed team members being yelled at and bullied by Samir, including a virtual meeting last week. People in the team have had to leave work due to stress, allegedly from Samir's behaviour. Sally is outraged by the reported behaviours occurring on such a critical project. She contacts Thomas to find out further information about the complaint and the bullying. She tells Thomas that Nina is the employee who called to complain about the bullying.
All right, so this slide really brings out some important issues, because I think probably all of you will be switched on enough to have appreciated that, Samir's running a team and probably doesn't have great leadership skills. So hopefully that would have picked up some red flags to Thomas or yourself if you were in that situation. And of course, the company's in a situation where it's not just dealing with a one-off scenario with, one person that's being bullied, but potentially a whole cohort of people that are being bullied, or what might be a culture of bullying or a hostile workplace culture. So it's not an isolated issue. It's not just one person that's in this. So before we talk through the rest of the issues, I wanted to put the second polling question up. And that is, do you think that the whistleblowing policy should be followed in relation to the report by Nina? So just to remind you, Nina's the employee who's been observing the stress, and she's made this complaint to Sally, who's the executive manager, the C-suite people officer. So do you reckon we should be thinking about whistleblowing at all in this scenario? Whoops. And I think Mel, I'm not sure whether these two questions are together in the poll. I think we've just asked the one question.
I think,
was that?
Yeah. Okay. Yeah.
So why don't we get the answers?
I got rid of the box now. Oh yeah, here it is. Ooh.
Oh, there we go. Okay, interesting. Okay, well that's good. And so 71% of you have said the whistleblowing policy should be followed, and that is the right answer. And the reason for that is we've got Nina, who's an employee, making a complaint to somebody who is an eligible recipient, a senior officer in terms of that people manager, who's the executive leader, and it's relating to what is a culture of workplace bullying. So we've got an eligible whistleblower, we've got a disclosable matter in terms of what's being discussed, and the disclosure is importantly being made to an eligible recipient. So for those of 30 or so % of you who didn't say we should be thinking about the whistleblowing policy, it's fair enough, because personal work-related grievances are carved out of what a whistleblowing complaint may be. So the important thing to hone in on here is that the bullying extends beyond one person. So it's not a personal work-related grievance where it might be impacting a full cohort of people. So we should be thinking about compliance with the whistleblowing policy, which leads into the second question, which should Sally have disclosed the identity of the complainant, Nina, without further consideration of the policy? Oops. So let's get the answers to those questions now. It's a pretty straightforward one. Or maybe it's not straightforward. Well, interesting. Oh, good. Sorry, I was looking at it the wrong way around.
The wrong way around.
So yeah, okay. So that's great. Most of you are familiar enough with the whistleblowing laws, which I sneakily didn't talk about at all, to know that if you're dealing with a whistleblowing complaint, or one that might be a potential whistleblowing complaint, then you need to protect the identity of the whistleblower. So what that means is that Nina's identity shouldn't have been identified without getting Nina's consent. So the two main obligations under whistleblowing laws, and again, I could talk to you for hours about that, is that you maintain the confidentiality of the complainant's identity unless they give you the consent. So in this scenario, she should have first said, are you comfortable for me to raise this issue and to talk about your issue using your name? So great that most of you got that one right, because I've done this training with lots of C-suite and executive groups of listed companies, and they have not quite got that one right. All right, so moving on then to the next part of the scenario. Over to you, Ange, to quickly read through it.
Yeah. Sally speaks to legal and obtains consent from Nina to investigate in accordance with the IT Pty Limited whistleblower policy. Sally is concerned by Thomas's general knowledge of the bullying and asks about the particulars. Thomas can't recall Shay's initial complaint, and he didn't take a file note of her specific complaints. IT Pty Limited commences an internal investigation, and the reports are treated confidentially in accordance with the whistleblower policy. Sally is mindful of keeping the project on foot and the pressing milestone delivery dates coming up. Samir, unaware of the matters that have been raised in the team, and investigated by HR, invites Shay to a meeting to have a frank and honest discussion that it is probably best she leaves the company, and offers a significant payment if she resigns. Shay complains to Sally about the conduct. Oh, Cilla, you're on mute.
Thank you. I've inadvertently pressed it on my headset. So look, some of the issues that we're dealing with here, the whistleblowing one has been dealt with. Sally's got Nina's consent to talk about it. File note, I mentioned it before, it's imperative to take file notes particularly where any complaints or concerns are involved. Then we've got the business considerations. We're seeing what is systemic bullying under the management of Samir. So there's obviously an important role for HR to play here. And then we're seeing these without prejudice discussion. So you can see that Samir, unaware of this other picture that's going on, is now going to have a discussion with Shay. And that essentially might expose the business to further further exposure under laws, because essentially a complaint has been made and then this person is being subjected to adverse treatment, for example, in the form of this without prejudice discussion. So if we ask this question, what do you think is it appropriate for Samir to or HR to be having any without prejudice discussions with Shay in the circumstances? So Shay, as you'll recall, is the person who's on the PIP from her bullying manager, Samir. We might get those answers up. I'm conscious of time.
Yeah, we've still got some questions to run through.
Cool. Great. So we've got a nice. So Ange, you've got a pretty cluey cohort of people on the line, which is great to see. So you know, it might be that the answer is maybe, but the correct answer is probably B, which is no. And the reason is that there's real you know, bogeys around having a without prejudice conversation with someone who is involved in a complaint. And as you know, that the purpose of a without prejudice discussion is to encourage them to potentially resolve a dispute between them. But quite often you'll see somebody who's not best placed to have that discussion starting that conversation. So here we've got Samir, who is the bullying manager, having this discussion to say maybe it's time to leave. And what that essentially means is that she's made a complaint, and the person who the complaint has been made about is then trying to exit her from the business. So it's not a great scenario, and it's not just about you know, having a without prejudice conversation at a less than ideal time. It's also about Samir not being aware that that process was on foot. So if we go now to the final part of the scenario, do you want to read through it?
Yeah. The workplace investigation made findings that Samir's conduct constituted bullying behaviour contrary to the IT Pty Limited's code of conduct and were systemic. The investigation uncovered further conduct that people were too afraid to speak about. Samir was never interviewed as part of the investigation and was exited from the business. Sally and Thomas are blamed by the CEO for the situation, and now IT Pty Limited is not going to meet the project milestones. The media is contacting the CEO asking for a statement. He's not sure if he relates to the reported culture of bullying issues or the crucial project that has been garnering media attention lately.
All right, so this is the scenario that we do unfortunately see, where, you know, the proverbial hits the fan and suddenly the CEO is ringing up HR or the manager to say what the hell is going on. So here we've got a situation where Thomas, the HRBP, thought it was a simple PIP, and it has turned into a horror whistleblowing investigation, a business nightmare, and a media storm. So there were many red flags that we had here that could have assisted in the handling of the situation. And it's not uncommon for simple issues to scratch the surface and for there to be a larger systemic issue underneath. And it is really important that HR plays a role in the very difficult task that can be asking the right questions of the business and essentially standing up to the business when things don't seem right. And it is grey, and I'm not suggesting that that's an easy job for any of you. So some of the issues that arise here are, you know, we've got findings, there's bullying conduct that wasn't reasonable management action. Nobody ever spoke to Samir about that. Maybe you didn't need to. There was a weight of evidence, but that might create an exposure from a procedural fairness perspective in terms of an action that Samir might bring. His been exited from the business. Was there a deed of release or otherwise? Sometimes the optics of that can be challenging to navigate. And we are seeing a trend where people are exiting, leaders that are falling foul of conduct expectations quite hastily, but that can bring about its own risks as well. And then, of course, we've got the practical reality where the investigation has meant that project milestones haven't been met. So there really is a delicate balancing act for all of you to navigate in terms of navigating business continuity, the politics, as well as promoting a safe workplace. And then the reputational damage for the organisation, whether it's relating to the systematic bullying or the failure to deliver the IT project or both. The mishandling of it along the way is exacerbating things and has got the CEO's attention. So this slide, I'm conscious of time, so this slide really is just a reminder of what I'd like you to do. Have a look at your casual contracts to ensure that they're reflecting recent legislation, ensuring that you've got the processes in place to deal with casual conversion, reviewing your contracts and policies to make sure that it's in line with best practice. You might be aware that the Respect at Work report that the Australian Human Rights Commission did focused on sex discrimination. There have been amendments to the Sex Discrimination and the Fair Work Act that has broadened sexual harassment to sex-based harassment. So many companies are amending their sexual harassment policies to deal with that. So again, that's something that you might think about doing. And again, just general takeouts for all of you to just remember that HR is obviously employed in the business. You often get asked to keep things confidential. I want you to really question whether you can do that, whether you should do that. You need to build rapport with the business, but you also need to be there to test them. The other things that I wanted to mention is, again, just ensuring that performance management processes, where there might be a complaint and there might be a performance management process, keep those two processes discrete, one from the other, so that you can then avoid an assertion that somebody is being managed out, for example, because of the complaint that they made. And again, file notes, please keep that evidence for your friendly employment lawyers as the need arises, and generally just trying to use these examples as a means to ensure that you can be upskilled and that your teams can be upskilled. I could say a lot more on this slide, but I want to have some time for questions. So why don't we move to the questions, Angela?
We've got quite a few. Just going back to the vaccinations at the start. So we have. I'm going to quickly. Sorry, we've got them in the Q&A and the chat, and they're not in order. So this. I'll go with the longest one just quickly. Given there is no clear government direction regarding mandatory vaccinations to businesses and only certain industries can mandate, what happens where a company is not part of an industry that mandates, but the company strongly encourages vaccination? However, out of the entire workforce, only one team member is not vaccinated for medical or personal beliefs, but management's pressuring the employee to vaccinate. The employee submitted an affidavit to HR stating that they will get vaccinated if the company accepts liability, that if they have adverse action, the company will have to pay any associated medical costs.
That's an interesting one. And look, it's an interesting approach. Adverse medical reaction, I assume that means. And look, that really in that situation is going to come down to a commercial decision for the company to make, whether they are agreeable to those terms. I'd be disinclined to agree. So I think the key there is, can the employee continue to do their job from home? If not, then it'll become a situation where it's an inherent requirement of their job to potentially be in the office, and you need to really understand, both the role that they're doing, whether there's a legitimate medical exemption. It sounds like there's not a legitimate medical exemption, and they're just looking for some catch-all because they might be vax hesitant. Most of my clients in that scenario wouldn't sign up to what is a very sort of, a question mark about what that liability might mean.
And so then another one. Oh, sorry.
Yep. I was just going to say, and so in circumstances where you're minded to potentially take steps to terminate that employee, then you would, if you're not in one of those industries, then it makes sense to wait until the government guidance is there. That'll give you that backup and protection.
And just sort of on that note, somebody made the point that I think Vic and WA have mandated vaccinations. I'm not on top of that news. Is that, how is that impacting things, Cilla?
So yeah, Victoria has done it essentially. So the bulk of employees that are going to be back at work have mandatory vaccination requirements, and WA was in the news today is heading down the same direction. So that makes it much easier for companies in those jurisdictions, irrespective of whether they're health workers or those other industries, to mandate it. There still does need, so they can have a mandatory vaccination stance, but there still will need to be that individual assessment, because there might still be a discrimination or a disability risk that comes with it. But it gives them comfort that they can have a mandatory vaccination status. And many organisations are saying, we strongly encourage you to get vaccinated, so not mandatory vax, but if you're not vaccinated, you can't come to the office. And that way we're seeing people generally wanting to return to the office, and so that they're tackling it in both ways without actually having the mandatory vax status at this point in time.
Because Hayley had a similar question. She says, we have an office environment and we're going to want everyone back in the office come November, though only for fully vaxxed. And it says, can we terminate once the government, I think it's the 1st of December, isn't it, where the government says, companies they want. Can we terminate if staff don't comply? And without answering the question for you, I'm guessing it just reverts back to what would have been pre-COVID situation. Is that right?
Yeah, look, I think as we go on, and that I mentioned on the first slide, we've got a duty of care under the work health and safety legislation to keep people safe, and so unfortunately it will come down to a case-by-case assessment of the individual employees, and these matters will be dealt with on a case-by-case basis in terms of legislation. But the cases that we are seeing are that termination, not being vaccinated in that scenario, is likely going to be a valid reason for termination. But then whether you can get off on, for example, an unfair dismissal will rely on the process. So it is important that you seek to understand whether the person just doesn't want to get it, whether there are legitimate reasons, a medical exemption, for example, and to really explore that. But we will see many people terminated, and so far the cases are on the side of the employer that's saying that is a reasonable decision to make in the circumstances. And as we see a spike, as we anticipate in COVID cases like we're seeing in the UK, when everybody's out and about, everybody's getting it, we're not dying because we're vaccinated, then the legitimacy of those decisions to not allow people that aren't fully vaccinated into the office will be much sort of lessened in terms of the challenge that companies will face.
Just quickly on that, Cilla, so I'll get back to the questions, but I haven't seen all the news this morning, but I know that the UK's, they're talking about there have been a few problems now, and I know that people in our European and UK offices have been using those quick flow tests, or the PCR tests, or whatever they call them. And then I saw something last night that said that I think we're having those tests here, but they've got to be administered by healthcare professionals, which kind of defeats the purpose really of how convenient they are.
Yeah, that's right. So it's lots of our international
backwards.
Yeah, lots of our international clients are saying, what about rapid antigen testing? Can we do that yet? And the answer is we're not quite there yet. But that will become the fallback measure that people will say, well, I'll have a test and show you that I don't have COVID before I come into the office. But we don't have that, who is a health professional in that scenario. But yeah, it's not a very easy way of addressing it in that way. So we're not quite there yet. And the country is kind of in catch up as we're suddenly opening up, and we don't quite have the mechanisms. And as I said, it is being left to corporates to drive this, which is a little bit unsatisfactory. But it was initially because there weren't enough vaccines. So understandably, the government wasn't going to mandate a position where there weren't enough vaccines for people to have. As that changes, and it has changed, we do expect that there will be government guidance from both the government as well as then the WorkSafe authorities at the Commonwealth and state levels that'll give you that clarity and comfort.
And just still on the COVID question, it's at the moment, employees under essential services contracting COVID can lodge a workers' compensation claim in New South Wales, but not in Vic. In this scenario, I'm referring to people in construction. My question is Cilla aware of any conversations around making changes in this for New South Wales? Insurance companies seem unable to decline these claims, even if they cannot be proven COVID was contracted at work.
Yeah, The shorter answer is no. It has been discussed, and that it's one of the classic issues of our state and territory-based systems, that there are those differences. I mean, we do have what is a relatively harmonised work health and safety regime, but the workers' comp system is still a state-by-state process. So no, I haven't heard that, but that issue of that disparity is absolutely on the agenda. So one would hope that will get tied up relatively soon.
Okay. And just moving on to a couple of the other, this is a quick question on the contract. So is there any indicative length of time of a rolling fixed contract that then warrants redundancy if the employer determines not to renew a contract?
That's a really good question. And it's less, by time, I'm assuming you're talking about the tenure of the whole employment. So,
yeah.
And, you know, but you might have someone legitimately on, for example, a 5-year fixed term contract while, you know, we build a mine or something like that. And so the greater risk is more repetitions of the contract. So one renewal might not get you there, but we see clients where they've literally got someone who's been on rolling fixed terms for 15 years, and that's an actual joke. So it's a bit hard with the time frame, because you could, in a year, for example, have 6 renewals of a 1 month or 2 month contract. But you know, the short answer is the more repeat or the longer the duration, the better. But there's no legislated time frame that says if you're on a fixed term contract for more than 6 months or a year, you automatically become an employee. But the thing to be alive to is that even if you're on just a single fixed term contract, if that contract doesn't end on the termination date, and the contract ends because the person is no longer required, there can still be a risk of redundancy in that scenario. So if it ends by the effluxion of time on that end date, no redundancy. But if it's being terminated early during the term of the contract and it is a redundancy scenario, then you will see companies paying, and you will see employees challenging to say that that is a legitimate redundancy scenario, and we would agree with that.
And then another question around going back to your investigations, actually. Should investigations be undertaken by independent third parties rather than internal HR management teams?
Such a good question. And such an annoying answer. It does depend. So we say to clients that, reasons to outsource an investigation might be that there might be a perceived bias, for example, that, the HRBP or whoever might otherwise do it is friends with XYZ. So bias might be a reason. In terms of people's comfort to talk to an independent person, that it might often mean that they're more open to disclosing the full truth to an independent. So if it's a potentially a little bit of a challenging issue to navigate, then that quite often means outsourcing is good. Another question to consider when you're outsourcing is should it be done by an employment lawyer or a workplace investigator that is a lawyer, to ensure that the investigation has the protection of legal privilege. So that's another consideration to make. So the short answer is it does depend on the subject matter, but certainly having it investigated by a third party does enhance the independence. It does assist the employer to say, look, we looked at this independently. It's not just an internal stitch up. This independent third party found this. So that can absolutely be helpful, both in terms of the parties to the investigation accepting the outcome, but also to the extent that you're defending a decision that relies on the investigation report, then you've got an independent third party sitting in the witness box rather than, Johnny, who's been mates with the respondent sex pest for the last 10 years or something like that.
Right, I think we're out of time, but look, there's a couple of just really good questions here, actually. So I'll do one or two more, but do HR professionals, should they look at obtaining professional indemnity insurance when they're giving advice, or are they covered by their employment contracts?
I can't say that I've, so the short answer is I would hope not, as in, no, I don't think that we're there yet in Australia. I know that some American clients in what is a much more litigious environment do sometimes ask that question. In Australia, the answer is no, they don't do it. And, 9 times out of 10, the conduct of an HR professional will sit with, unless the person's flagrantly doing something that they shouldn't, sexually harassing someone or bullying someone and the like, then the company will take responsibility for that. And that is the benefit of being an employee rather than a contractor, that your company, your employer, bears the onus of your actions. So it is a scary world for HR professionals, but we're not seeing people seeking to get insurance. What I would say is, though, that something to be alive to is that HR professionals and lawyers as well are sometimes being joined to proceedings. So you might have an adverse action general protections claim where the employer is the first respondent, and then you have an HR manager who might be the second respondent for their role in the management of, for example, a dismissal. So it is a job that has increasing risks, and you can have personal liability. There are decisions now where HR professionals have had penalties against them personally for their role in a contravention, but it doesn't happen often, and it's generally only happening where the person has done something wrong. But what it does mean is, if you're being asked to do something that you're not comfortable with, you really need to have that open discussion and push back.
Oh, thank you so much, Cilla. We've got a couple of other questions, but I think we'll have to wrap it up. We always run over, don't we? But yeah, look, thanks so much again. It's always great to hear you give out your advice and tips. So as I mentioned, for those still on, we'll share the slides later today or tomorrow, and then we'll get the recording out as quickly as we can. We've just got a backup of production in our production team. Keep an eye on our website. We're starting to plan some events for next year. I would love for them to be face-to-face, but we'll see what happens. As we get further into our COVID, coming out of our sort of COVID lockdowns. But yeah, look, thank you so much again, Cilla, and wherever you are in the state, in the country, enjoy your day.
Yeah, thanks very much. Thanks everybody for being smart cookies, answering all the questions really well, and hopefully we get an opportunity to have a face-to-face gathering next year. Thanks so much, guys, for hanging on as well. Have a good day, everyone. See you later.
Bye.
Bye.
Bye.